Thanks everyone for coming into the room. I know it's tempting to stand out there and get your teas and coffees, but come and join us if you can. We're very lucky to be here this morning with a panel that I'm about to introduce for a topic that I think a lot of us have some experience of in some way or another, and that is unique challenges of disputes involving states and state parties. Now, we are mindful that there's a lot of topics this week across many cities as part of India Arbitration Week. And what we're hoping is that we will be able to engage you from different aspects of this topic. And so I'll introduce in a moment the different panel members you have that will give us, I think, a very varied experience and set of views. So let me start by introducing Salim. Salim Moollan KC is a barrister at Brick Court Chambers. He specializes in international commercial and investment arbitration. He's acted as counsel in high-profile investment arbitration cases, including a case that I and many other people have been talking about for over a decade, the White Industries versus India case, Philip Morris Australia, and another case that has made headlines for many different reasons, Cairn Energy in India. He currently acts as lead counsel in a number of prominent investment matters for both states as well as investors. And also in the commercial field, he acts in high-value cases in various sectors, including energy and telecoms. He also sits as arbitrator, both party-appointed and chair, and both in investment and commercial arbitration matters. We then have to Salim's left, Ms. Zarina Chinoy, who's General Counsel of the EPC division of the 150-year plus engineering and construction giant, the Shapoorji Pallonji Group. Ms. Chinoy has been at the helm of various matters, both contentious and non-contentious, for the group, and will share with us her experience of various contracting roles with states as well as state-owned entities from her perspective on the client side. Then to my right and to Ms. Chinoy's left is Tarun Bhatia, who's Managing Director and Head of South Asia for Kroll. Tarun is in the Forensic Investigations and Intelligence practice of Kroll, based in the Mumbai office here. Tarun has extensive experience in evaluating, measuring, and monitoring risks across corporate India over the past 15 years, and he's a well-regarded industry expert for financial services and structured finance. So again, from the perspective of sort of looking at it through a money lens, I suppose, and through a forensic lens, it'd be interesting to hear from Tarun on this topic. And last but not the least, and straight back at the end of this table is my fellow partner, Lucia Raimanova with Allen & Overy. Lucia has been based across various offices of A&O and is currently the head of our Central and Eastern European arbitration practice, but has done a fair bit of work in other jurisdictions like England and Wales, where she's a solicitor advocate, and also here in India, including a long-running matter which Lucia and I have been doing together. Lucia has 15 years of experience in both commercial and investment treaty matters all around the world, and also sits as arbitrator. So what are we going to do today? And I'm Sheila, and I'm your moderator for today, and I'm also with Allen & Overy. I'm based in Singapore, but spend a lot of my life in different parts of this country, and I can't get enough of it. Okay, so just moving on to how we're going to tackle this topic today. What we're going to do is take the structure in chronological order, and I'm going to, I guess, put questions. I have the best role here. I just get to put questions, and I'm going to invite the audience to as well, better for it to be interactive. And I would say, controversial questions, I don't mind, but if the panel refuses to answer them, then we'll bounce it around other members. So we'll try and get everything answered if we can. We're going to start first by looking at trends, nuances, risks, and challenges of disputes involving states and state-owned entities in particular. Now, of course, there are challenges in all sorts of disputes. Sometimes they're cultural, sometimes they're just tactical, sometimes they involve a particular counterparty or a particular client, depending on which side you're on. And that's what we want to focus on, is when you have either as a client or a counterparty, somebody that is belonging to a state or is a state-owned entity, what are the trends that we tend to see? What are the risks and challenges of operating in that space? And then we're going to try and convert them to strategic considerations. So building from our past experience, when you're looking to matters next, what factors should you take into account when you know that the party that you're involved with, as I say, on either side, is state-related? And finally, I want you to walk away with something, and so will I, from this panel, which is practical tips and anecdotes, just to take away with you on, experience that we'll get from this panel. So if I may start with the first heading of our structure, which is challenges, trends, nuances, and disputes involving states and SOEs or PSUs, depending on where you are. Salim, if I can put you on the spot first, you made the mistake of telling me your extensive experience in this space on both sides, actually, for and against state, actually investment and commercial, counsel and arbitrator, in arbitration and court, so lots of different angles. Can you tell me, if you can, stringing a thread through that, what are common challenges that you see in disputes involving states?
Yeah, thank you, Sheila. Yes, as you say, I've acted on both sides of disputes involving states. So perhaps to answer your question in three strands. One would be, first, the nature of your client as a state or opponent as a state. I think the first thing that is obvious is that the decision-making process would be much slower than having a corporate client. There's also much more difficulty in getting decisions at all. For example, it's often said that it's very, very difficult for a state to settle because the default option is, the bureaucrat will just pursue litigation, then it's not responsible for anything at all. If you take the decision to settle, then of course you can be accountable for it later down the line, further down the line. So that's another common problem. And then still on this first strand of the nature of your client, there's perhaps, I wrote down the word arrogance, but it's not arrogance. It's bureaucrats will operate within the boundaries of their domestic legal system. And I don't mean that only in India. I think it's everywhere. So for example, if you take India, your normal civil servant will be used to operate within the constraints of Indian judicial review proceedings, for example. He will not think, or she will not think, that the decision could be amenable to arbitral proceedings involving a procedure he or she has never heard of before a tribunal that will not be an Indian court, and applying substantive standards, again, they have never heard of. And that creates problems, because when you step in as counsel and are trying to advise them as to what the risks involved are, it's so foreign to what they're accustomed to that, of course, tensions can arise. So that's the nature, if you want, of the client itself or opponent. Then the second strand would be in terms of procedure. Are there particular challenges that arise because of a state being involved? Well, the same factors, of course, will come into play. If you are before the courts of that state, then I don't need to develop the problems that you might be facing. And even within neutral arbitration, there is increasingly a procedural distinction being drawn whenever a state is involved. So to take an example, some arbitration rules will say, well, if it's a state, it has to be 3 arbitrators. The ICC rules, particularly careful. Whenever a state is involved, the court will look at it with a very different eye. And some of you may know I chaired the work of UNCITRAL on transparency in investment arbitration. And the call there wasn't simply for transparency for investor arbitration, but for every arbitration involving a state. And I think that's not a trend that's going to go away. So that's on procedure. And finally, Sheila, on substance, well, clearly you may have to face problems of immunity. And again, you've got the different substantive rules that can apply in the realm of investment arbitration. And that's something I think we're going to be discussing later on.
Thank you, Salim. That's a very helpful set of factors. I actually want to pick up on the point you made about bureaucrats or people operating on behalf of the state who tend to operate, or at least assume they can operate, within their domestic legal system. And as a result, that can create certain tension, I suppose. And maybe asking Zarina and Salim to comment on this, do you then find that when you are dealing with a state state-owned entity on the other side, their willingness to accept a more neutral forum, it's just difficult to get through to them? Are they often unwilling to operate outside the parameters of their domestic system that they understand the best?
Yeah, Sheila, absolutely. I mean, you have to understand, as he rightly pointed out, their mindset. They are more bureaucratic. They have to work in a very constrained purview. They can't, let's say, walk outside the four corners of this room. It's not like a corporate where I can take it maybe to the promoters and maybe have a strategic discussion. These are ministries, these are ministers, these are civil servants, and they have various structures that they cannot move out of. So they have a comfort zone, and of course that they would prefer a venue, a forum, a seat, whatever, within their jurisdiction where they understand it, where they understand the nuances, where they believe that they can control it as well. I mean, control in that sense, it's a mindset, right? It's in India, I can do it. It's in my jurisdiction, it's in whatever country, in Europe, in Africa. I am a minister there, I'm a civil servant there, I know how it works. It's easy for them to understand it in that sense. We as corporates are able to go anywhere. We like to diversify. We see the world with a different lens. They see a world with a different lens. So getting them to accept something neutral, yes, that's pretty difficult. In fact, if you talk about it at the beginning of a transaction, they will say these are our parameters, this is set, this we cannot move from, and one of them will be the arbitration. It's always there.
And do you negotiate that with them, Zarina? Do you say...
We do attempt to negotiate it, but we do know very often that that line may not move. There are other things in the commercial contract that will move. But these, I've seen, are mostly non-negotiable. They may give you a little bit leeway with the venue at best, but nothing else. And the law, the governing law will generally be of that country or that nation's. That's not going to, that I haven't seen change. I mean, you might have, but I haven't.
Well, law, I think also, and maybe your experience would obviously be more relevant, I think, as someone who does negotiate these clauses. What I see in disputes is that often when you speak to the client ex post facto, they will say, well, governing law, we gave in, doesn't matter much, because we wanted to ensure the neutral forum. So the real area of dispute tends to be where the dispute will be resolved. So that's the experience I have. Otherwise, I couldn't agree more with everything you just said. And to add perhaps a little facet to that, I think that also explains this backlash against investment arbitration. We can discuss it to some extent, but I think one aspect which is not discussed that much, but I think we need to discuss, and I've been quite vocal in saying the system has to be changed, but I've always said the system cannot disappear. Why? Precisely because it is a forum that is neutral. Perhaps it ought to be tweaked, perhaps it can be made different in other ways, but it is neutral. Because I do think it's a problem. Completely understand that bureaucrats will need to move within the four corners of the room. But on the other hand, they ought not to be immune to real scrutiny of their actions. And there's a problem when they rely on their own cause or whatever forum they know to say there will not be real scrutiny, which is really what investment arbitration initially was supposed to be about the rule of law.
And Salim, do you think states do adjust their thinking or are getting better at adjusting their thinking when they know that the forum is a neutral international one as opposed to home turf?
Not really, because it always comes too late. And what I mean by that is that the bureaucrat who will have taken the decision is not going to be someone at the Ministry of Law. It will be someone at the Ministry of Telecommunications, it will be someone, someone else. And so one needs to disseminate information. And when you see the way Argentina has dealt with it, they now have a system whereby, of course, they deal with the disputes, but they also disseminate information across their ministries. And it's something we've tried to do here, and I can't say we've had much success so far. But it's very important, because then you prevent disputes from arising.
And I guess pivoting from that, and maybe to Lucia, when you are then advising a client on commencing proceedings where, that client could be the state or it could be the counterparty, but you know that, the behavior will be dictated by the factors that Salim and Zarina have set out. What factors do you take into account when deciding what to say to the client about whether or not they should commence proceedings in that neutral forum?
Yes, so I think we can all agree that no one commences disputes against states in particular lightly. That's for sure. A lot of thinking goes into that. Obviously, the considerations will differ from case to case, but I would broadly put them into four buckets, if you like. So there are considerations of the relationship with the government after you commence the dispute. There are consideration of the merits of your case, then time and cost, and most importantly, enforcement. So on the relationship, obviously, the big question is how will the dispute affect the relationship with the government? And if you are a business who is already exiting because something pretty drastic has happened, so that you have to exit the country, you may not have the same considerations as when you are still operating in the country. If you are still operating in the country and you are also in a highly regulated sector, which is even worse, then the government has lots of tools to deploy to make your life difficult. Obviously, the government will be careful not to commit another treaty breach, but it can, if you're a bank, for example, look at your anti-money laundering compliance a bit more carefully, or it can scrutinize your tax return a bit more carefully. So you can expect a battle from other fronts as well once you start the dispute. And even if it's a commercial dispute, which is a bit less political, and you are not questioning the government's sovereign powers, you have to ask yourselves, are you going to get the next contract from the government when you're in a construction industry, for example, or if you're operating in a JV with the government, you may face operational issues, right? Because even though the government may not be deciding every day on an operational issue, they do have decision-making or approval powers so that the consensus building may be a bit more difficult. Then moving on to the merits, obviously you need to have a proper analysis whether you are likely to win. I've got some statistics for you as well. So despite the backlash against ISDS, as Salim mentioned, you have to bear in mind that states are more likely to win. So they win in 56% of cases, or some of them are also discontinued. And when you win, you are typically awarded only 40% of the damages claimed. And I'm quoting from a study conducted by our fellow partner, Matthew Hodson, who spoke here last year. And that sort of takes us to the time and cost considerations. Obviously, you have to, these disputes do mean a substantial commitment of time and cost on the investor's part, in particular. So according to this ANO study, which captures data up to 31st of May 2020, the mean cost for an investor is $6.4 million. And then if you lose, you may have to pay some or all of the costs of the state's defense. That is slightly lower. The mean amount is about 4.4 million. And there's also the cost of the arbitration. And in terms of the duration, these disputes, the mean duration is 4 years, 8 months for exit, and it's 5 months shorter for ancitral. But then, interestingly, the higher the amount in dispute, the longer the case can take. So when you're looking at a class of claims above 1 billion, it's, the average is 8 years. So these are really significant time and cost commitments. Obviously nowadays you can also get funding, but still you have to have your ducks in a row. And then finally, on enforcement, and no doubt Tarun will then have more to say on that, but obviously you will need to be comfortable that you will see some money in the end of the day. You are, of course, considering whether you have access to the ICSID Convention or a New York Convention. Both are problematic with, in India as far as treaty disputes are concerned. You know, what history does this state have in paying out on awards, and if enforcement in the country itself is difficult, which it typically is for treaty disputes, then does this state have sufficient non-immune assets that you can enforce against outside of jurisdiction? And then I think it's probably more on enforcement for Tarun.
Yeah, thank you, Lucia. And I guess we'll come back to these questions around the relationship, with the government. Do you need to maintain or be mindful of, what's happening in a dispute process versus outside? But actually, I want to know from Tarun and Lucia just what you alluded to about enforcement risks. Do you get asked, Tarun, often sort of upfront in a matter, I've got these lawyers telling me to pursue this dispute for X number of time and this is the merits and they feel quite good about it. But what's going to happen at the end? Am I going to see any light of day where money is concerned? And how do you deal with that? Or do you deal with that differently where there's a state involved?
Thanks, Sheila. So yeah, we always wish state comes to us sooner than when they actually do, because most of the things, can't be resolved by that time. But I think, specifically in India, and just without spending more time on it, one or two other challenges that we have seen is, broadly the thinking, given we are a large country, so populist that, the fact that you're paying taxpayers' money and there is some level of media noise, I wouldn't say scrutiny, also plays a factor, and that influences even on enforcement. In our experience, all the points raised here are very relevant. I think increasingly, because India has many SOEs who also operate outside India today, whether the state itself is a party to the arbitration agreement becomes an important question today. And what we are increasingly seeing is, the Hague Convention being brought in more actively, because there itself is a lot of procedural aspect involved. So just on the process side, there's a lot of time that gets spent, and we believe that itself takes a lot of time. But beyond that, from an enforcement point of view, there are three key questions that you need to keep in mind, especially in light of, we are looking at neutral jurisdiction. The first is, will the courts enforce the award? That itself is important, and that's a question we get asked when there is a neutral jurisdiction, because they want to know, past incidents, how have they looked at experts' recommendation or whatever the expert has, kind of claimed. I think the second is themselves being aware where their assets are, because, in India, Kane is a good example, and there have been a couple of others where a threat of global asset search and attachment to the sovereign has been made. And we are increasingly seeing SOEs talk to us saying, if there was a dispute, which of my assets could be, at risk? And that's very preemptive. It's not as active, but that's a question being posed by them. And I think the other thing which is becoming increasingly important, and I say that from some of our global experiences, the whole aspect of sanctions. Because, even if you need to do enforcement, if there are sanctions, then the local jurisdiction has a lot more stay. I think Russia is a good example where, the Russian courts need to play a role today when it comes to enforcement and attachment. So I think that's important. Two other points, where we spend a lot of time is, I think when you're thinking of enforcement, you have to think of attachment. And a lot of time we have seen situations where, a state and how do you define a state gets questioned. And similarly in SOEs, is an SOE accountable, or can you hold the sovereign also accountable? And that's where you look at, from pure economic interest and control to aspects of, who are the decision makers. I fully agree with what Salim said. I think the process in India is very regimented, if I can use that word, and that is something which delays the process. But we are now seeing, ways that this gets countered. Litigation funding is still relatively new to India. We've seen a lot of people meet different stakeholders, but we are now looking at political leverage, as something which is being used even by India. Because I think, the whole story about if India is attracting a lot of money, it will need to kind of, toe the line. We haven't seen that play out. India's own view is that, if the relationship was commercial, then you don't have immunity. That's the stance India has taken in the past. But we are today being called up by the government on state-owned enterprises where, they are the claimant to understand what can they do, when should they get in. So I think things are changing a bit more, but the timelines still remain very long.
Thank you, Tarun. There's a couple of interesting points I wanted to pick up on and actually maybe get, Zarina, your reaction as a sitting in the client seat. Some of Tarun's comments around a state-owned entity actually thinking proactively about, asset tracing against it actually. I just wonder how much of that do you see on the negotiation side? And we'll come on to, what are things we can do differently or whatever from the start of a matter through to the dispute stage. But do you actually see that being taken into account, or is it really when something gets heated, that somebody goes to Tarun? I wanted to get your sense at the negotiating table.
So Sheila, hindsight is always 20/20. It happens both ways. There are times, it depends on the kind of state that you're dealing with, that you may want to look at that upfront, or are you in a hurry, or whether is there competition and are you bidding against a bunch of people? All of these factors have to be kind of taken into consideration. So there's no one answer I can give you. Whether we see it at the beginning or the end, it just depends on sometimes how the transaction plays out. And it's very often it's not it doesn't come straight to the legal department to have a look at it. It's commercial. At the end of the day, business is business, and that comes first. And when you're talking about asset tracing, we lawyers always think of the worst and plan accordingly. Commercial people plan for profits. And I think that distinction is something that you need to take care of. That I need to understand before I can answer that question for you. And like I said, there are so many moving parts. That's not an answer I can give you anyway. I can't give you a generalized answer. But we do look at it. We do look at the ability of that state entity to pay up. We do at least some level of risk analysis, because it is necessary. At the end of the day, if we're not going to get paid, even though that profit margin is 20% and we're not going to recover, how does it matter that we do the project or not? So we do look at it. There is some amount of risk analysis. There is some amount of business objectivity that goes into it as well. It sometimes does happen in the course of the project itself, not just at the beginning. It depends, and based on that, we also do take a decision of whether we want to litigate, whether we want to arbitrate, whether we want to go ahead and fight. And but you also have to understand that state-owned entities, especially when we do projects for them, they require upfront guarantees from us as well. So they control some of our assets, some of our cash flow, and they do use it. I won't use the term blackmail, because that might be a bit harsh. But they do use it to control us. They do use it to force certain decisions that we have to make. So we have to take into consideration a gamut of things before that answer can be given.
Thanks. That's really helpful. That's sort of proper, commercial legal exposure, right? Your comment about deals being done and people being focused on the profits versus how we look at it is interesting. Obviously, some of us have spent all our careers being told by our transactional colleagues not to be anywhere near when a deal is being concluded, but then they just call you in the background and say, does this clause work? Don't say no. But as you rightly say, hindsight is 20/20. I do want to pick up on this theme sort of that's coming though about, and maybe moving into strategic considerations, the sort of second arm of our discussion, is when you are then looking at it as a matter of hindsight and looking at your experience, and maybe Salim, to you, do you ever get asked, what's the point? I can go through a neutral process, but ultimately it's just postponing the inevitable, which is coming back to home turf for the state side. Why not just pursue them domestically and, cut losses or factor that into your commercial bargain, as Zarina said? So what do you say to somebody who's coming to you saying, what is the point of still going offshore to a neutral forum, whether investor or commercial, as opposed to just staying on the ground?
Well, I guess it depends what the alternative is. It depends on the quality of the courts of that given state. I think it's fair to say that the courts of England could be more neutral about ruling against England itself, Great Britain, or a state entity than the courts of some African countries might. It's just the reality. So you have to look at what the alternative is. Then I wouldn't assume that you must come back home or to home turf. In that, as we've just heard from Tarun, you may well have opportunities to enforce elsewhere, and experience has shown that even when these are difficult, not very successful, with long-running sagas, it is a thorn in the side of a government, and therefore ultimately they want to get rid of it, so that helps. But I think the way I always try to think about these issues, and perhaps also discuss it with clients, is that you need to look at investment arbitration, because that's what we're now talking about, as part of the armory of what you have. So I was just discussing with Zarina, is it something you look at, when you're developing your projects in the same way as you would, say, your tax considerations, that you have access to investment arbitration? I think it's important to do that, because it doesn't take very long to ensure that you have, say, an SPV that's incorporated in the right place. But it means that you have access to it, and states don't like it. They don't like, for all the reasons we've been discussing, the idea that they are going to be the acts of civil servants, of ministers, of the powers that be, are going to be scrutinized before a neutral forum. So there's a political angle to it that can be used cleverly. You should not overplay it, but I think it's a useful thing to have.
Thank you. And just keeping to this theme about how to exercise that choice, and just as an aside, and it's in the public domain, so I can sort of share this, but we at Allen & Overy acted for a Japanese automotive company, Nissan Motor Company Limited, for a treaty claim against India for the reimbursement of certain incentive payments as part of their wider investment into India. Plant in Chennai. And one of the key questions on the table was, which route should we go? And after much consideration, we sort of pivoted them to the treaty route, and that led to a settlement, which was really great, but it also had a lot of other clients call us and say, how come you haven't settled my case with the state? So sometimes, as you rightly say, you sort of factor that into your overall thinking, but it's just a leverage.
But Nissan was, if I remember correctly, and of course you'll know much better, but a bit of a special case, because it from the outside, a little bit on the inside as well, it seemed that there wasn't much dispute that this was due, and it was a question of finding a way to get everyone to accept it without losing face too much. And I'm not sure that would translate into a more complex. Do you think that's fair? Or?
No, I think that's absolutely right. And I think ultimately it does also show you that when it comes to the battle itself, arguments are still made, but ultimately one has to step back and look at the commercial realities, what you're saying, and I fully agree with that. And actually on this question of when there is something more complex you want, I think Lucia, you were saying, sort of tends to be, a 3-member tribunal, and since Salim was saying that, how do you even take a decision when you're looking at commercial arbitration versus investment treaty arbitration? The statistics you gave us, Lucia, some clients would hear that and say, I don't want such a long drawn process. I'm just going to go commercial or not. So what factors do you talk to clients about when deciding which way to pivot?
Thanks, Sheila. So, Nissan aside, I tend to advise clients to go commercial if possible, because as it's coming out, it's less political, less publicity around it. There is less scope for jurisdictional objections, which tend to prolong the dispute. The contract laws of the national contract laws are much more developed than international law is, so you do have that the outcomes tend to be more predictable. I also find that arbitrators in commercial disputes and deciding about sort of breaches of contract are less influenced by sort of considerations of equity and how their decisions might be perceived by the public, which I find is increasingly the case with treaty tribunals, but I'll welcome Salim's views on that. Against that, of course, the considerations that are already mentioned, that some states take treaty claims more seriously, so you may likely achieve a settlement more when you go the treaty route, right? So you can use it as a political leverage. Also, an enforcement consideration is important. If you do have access to ICSID under treaty but not under the contract, that will play a role in your decision, because obviously ICSID is much better for enforcement. And also, if you need to challenge the actions of the sovereign, such as a passage of a law, or bring in some sort of broader factual framework, such as a campaign against you that is not strictly contractually relevant, then it may be better to go the treaty route. And then, I don't know if you want me to talk about if both are pursued in parallel, but I think maybe then there are, of course, situations where you can pursue both in parallel, but you have to have good reasons for it, and you also have to then face various objections that the state will bring. And I think Salim will probably have more to say on that, because in preparation for this, I noticed he's written a long article about parallel proceedings. But you may face questions about double recovery, so you may be expected to provide an undertaking that you will not seek double recovery. You may even be forced to elect which route you are actually, or which arbitration you are pursuing, or whether one of them should be stayed pending the outcome of the other arbitration. You may face accusations of abuse of process. Then if the parties are same, or at least the previous are parties to both arbitrations, you can also expect that the evidence and the pleadings will be used in the other arbitrations, so consistency will be key. And of course, if one tribunal already renders their decision, for example, that there has been a contractual breach, or the other way, that the state didn't terminate the contract in accordance with its terms. If that decision is relevant to the treaty dispute, then you may be bound by it, by the principle of res judicata. So these are some of the considerations that one is thinking about, but maybe Salim has more to add.
Yes, I was going to ask Salim if you want to add to that, in particular in a situation where, and you may or may not want to address this as part of your answer, where, you know, having agreed a certain forum, you find before you're even making the strategic decision, there have been local proceedings already commenced somewhere, which you then sort of discover the existence of. You know, how do you tackle that as part of your strategy?
Right. So there's quite a lot in what you both just said. I'm just going to try and answer those quickly and in as structured a way as possible. First, I respectfully completely agree with Lucia that if you have access, but there's some qualifications, to a neutral commercial arbitration in a, secondly, safe seat against, thirdly, a solvent entity, I would every day pursue that. And one should be quite careful, just to develop one of those points, about what one means by a neutral seat and a safe seat. Let's take two examples. India. Is India a safe seat at the moment? I think the litmus test is always, how are the courts ultimately going to decide? How quickly, how safely? And I think everyone recognizes we are not there yet. We're working very hard on this, but you still get decisions such as this stamp duty decision, and that sets India back. So, perhaps in a huge case, especially if you're an Indian company, Indian state, you might not want to have your seat in India. One should not assume also that all seats remain safe in the way we think about them, and that's why I was going to talk very briefly about England. We've had a decision of the Supreme Court 2.5 years ago called Anka against Chubb that decided that the law of the contract effectively would normally govern the arbitration agreement, and also decided that this would normally take out all the non-mandatory provisions of the English Arbitration Act. So suddenly you've agreed to an English seat with an Indian law, governing law, and separability, which is a very important protection to ensure the effectiveness of your arbitration agreement, goes out. The principles of interpretation of your clause under English law don't apply. Indian law will apply. So to give you a very concrete example, there was a decision in 2005 against one of the electricity regulators about tariffs. And the English court said, English law will decide whether that's arbitrable or not. Following Anka, that's no longer English law, but Indian law. And we've had a recent decision last year of the Supreme Court here in India confirming that that's not arbitrable. So you think you've agreed to arbitrate in a safe seat, but you haven't, because of a jurisprudential development. We're fixing it, and the Law Commission is now going to change it. But you have to be careful about that. So that's one aspect. Sorry. Then just to answer 2 points that you raised, 2 points that you raised, Lucia. You said you feel that investment tribunals now are more and more ruling in equity, sort of trying to see, how's the public going to perceive that? Perhaps. Others make the argument that these tribunals are not aware enough of public, international, and public law, and are too commercial. It being said that the proper analogy is not commercial law, but administrative law. So there are two sides of the coin there. But I think the problem is the looseness of the standards, and the fact that you've got ad hoc tribunals ruling each differently, each separately on those, which is why some of us, we're not saying, again, it's a panacea, but say we need to consider whether there is a way of creating some systemic stability. And that's where the idea of a multilateral investment court or an appeal mechanism, something to introduce less looseness, less flexibility, so that we don't have that criticism. And so we're considering that, of course. On parallel proceedings, yes, I gave a Hague lecture. It's intensely complex, so I'm not going to go into that. And finally, on your question, Sheila, on local proceedings. Well, again, if you've got a developed system of arbitration law locally, then there are mechanisms under the New York Convention to stop that. If you don't, then you don't. And then you end up in a wide industry situation, effectively.
Thank you, Salim. That's very helpful. I was hoping you'd take us through the lecture, but maybe we can. No, I'm kidding. We can see maybe for another time. But actually, looking at the choice of system and how much sort of one has to think about that, and as you say, sometimes what's perceived as a right answer may actually not be for the issue that is prevalent on your particular matter. I wanted to pivot back to Zarina to ask you, Zarina, when you are sitting across a table and you have, and I appreciate it may not be you, it may be the commercial team, and they sort of come to you, and you know that the counterparty is another commercial entity versus a state entity. Do you operate in a different sort of mindset of caution, I guess, relatively speaking, in those two different scenarios, or does it not actually bother you at that level?
No, Sheila, that's extremely important. Whether am I sitting across a commercial or a state, my mindset changes accordingly. Commercial is it's easier and it's difficult. It depends on the level of dispute or the level of trust that we still have. If it's a commercial entity, we both know that at the end of the day, we would still both like to come out with some sort of win, like you said, save face, and that may be more a practical solution. With the state entity, like we've all said, you have to jump through a bunch of hoops before we can get a decision. Everything is slow, everything is more bureaucratic. There is that level of scrutiny, so when they do send across a proposal of settlement, there will be, what is the settlement for, why is this happening, and therefore why did it occur? All of those things come into play when they go to their settlement committee, etc. But in a commercial dispute, not so much. It will be across the board, and we will know, and we will be able to talk about that easier. So yes, the mindset changes very much according to who is sitting across the table from me. What is it that I want also at the end of the day? In a lot of senses, time is money that we get. But if it's commercial, it's money oriented. But if it's the state, like you said, a lot of times it's also about saving face. And when we go to a state entity also, one of us have said that it's very important to understand where our next business is coming from. And if that state is going to blacklist us, then if I'm sitting across a state, I'm going to be very mindful of that. And my tactics will change accordingly. So it does play a big role.
Thank you, Zarina. And just sticking to that, and maybe you, if I may, you mentioned this, the prospect of what will happen to the future relationship as one factor. Do you see are we wrong to just group states and state-owned entities all together? Is there actually a varying degree of how they approach these situations? So might there be some states where that's not likely to happen, but other states where it's almost inevitable? And then in another scenario, might there be some situations where a state actually understands its obligations, but it just needs to go through for accountability reasons? Another point that was made, I think, by Salim earlier, accountability reasons, it needs to go through the hoops and be presented with an award before they pay. So are there actually factors which we are grouping maybe unfairly in a very broad brush category?
I would say yes. State entities, they vary. They're as diverse as we are sitting out here. There are some that are proactive, there are some that can take decisions quicker. They have committees set up, there are dispute resolutions that are set up and they're structured, they are acceptable to them. And then there are entities, of course, that are rigid. They have their procedural mechanisms, they have their bureaucratic mechanisms. So yes, the spectrum goes all the way, north to south. That I will say. But in terms of the last question that you asked me, in terms of scrutiny, that I've seen across the board. They have to be careful, they have to dot all the I's and the T's before that settlement comes across.
Right. Tarun, I was just going to ask you to add to that from your lens.
Yeah, so I think, couple of things. See, I think, and just sticking to India, our experience with different ministries has been different. So even if you take one state or one sovereign, I would say, there are ministries where the bureaucrats get it. The discussion is already 3 steps ahead, and they appreciate. They still need to go through the process because, unfortunately, in a country like India, enforcement from a different perspective, enforcement agencies, CAG, that is playing an active role. And the more you work with bureaucrats, state-owned banks, you realize that it's not just their intent. They are accountable in very different forms than many of us or a private organization is. So I think that also plays a role. But we have seen, same sovereign, 2 different departments approach it very differently, where the ultimate decision making may still be similar, but they go about it very differently.
Thank you. And Salim, I wonder if I might ask you if, I don't know, there's any experience you want to share of this topic of different conduct by states sometimes, and what you see is not actually what's going on behind the scenes, of course, without divulging anything that...
Yeah, no, I completely, respectfully agree with what Tarun just said. You cannot brush every government department with the same brush. They are very different. And it's interesting because I think, for example, if this country were to do a survey of what's happened in cases depending on how they reacted, invariably when we've had immediately cooperative departments, we've done incredibly well. I can give one example because that's a positive one, which is the litigation against started by Mr. Krishnan, who's a Malaysian national, against India. The relevant department engaged very early on, including in the selection of the arbitrators with the process. And it was a resounding victory because, you know, the merits were sound, etc. And it's much easier, and they're working with you and trying to find solutions. Another anecdote is, you know, you need to insist and insist and insist to meet your real client, who's going to be the permanent secretary of the relevant department. And then when finally you manage to get an appointment, you're told you're going to have 3 minutes. You know, might need a bit more than 3 minutes. And then you go into the room, and there's about 10 people walking to the room with you just to try and make sure you don't say much. And then you're sat down and you're given a lecture about how the case is going to be handled. That I don't think is very helpful. But you end up, you know, you have to do your job. So, you know, my answer that day, you want anecdotes, I'll give you an anecdote. My answer was, that's wonderful. I mean, I wish I had more clients like you, because then, in fact, you don't need me. Because if you do everything you've just said, you're going to lose the case anyway. So why pay a lawyer? Then they listen. But you shouldn't have to do that. So yeah, so that's what will happen.
Thank you. That's very interesting, and I maybe that takes me to our final sort of segment on, you know, what are tips that we can take away from this panel and what you've shared with us. And I mean, Lucia, in some ways, you probably get asked this a lot in your practice. You know, what are pre-dispute measures? You know, Salim shared a very interesting anecdote about, well, you know, depends on how you actually handle the case in the background and the lead up to the commencement of the proceeding. But even before it's brewing, you know, how do you, at the transactional stage or at the operational stage, what are things that you can say to a client on pre-dispute measures that you can adopt to avoid escalation?
Well, just sort of as a general matter, I find that the treaties are actually quite good in encouraging settlement, because they always provide for that a notice of dispute has to be served before you actually file a claim, and then there is a period of negotiations, the cooling off period, 3, 6 or 12 months. I think the India model BIT has 6 months, so it actually forces you to negotiate, and you never know. I would encourage everyone to try. We had once a situation where a military stormed a hotel and essentially expropriated the hotel, and the government simply wasn't aware of its treaty obligations, and so when this was explained to them at the meeting, they just wrote a check to our client compensating them for expropriation, so there was no need for further dispute. That's rare, I admit, but it can happen. But obviously there is a lot more one can do before you get to the notice of dispute, and there can be an engagement when a measure is also brewing. And I sit in Slovakia on the British Chamber of Commerce, so I do see foreign businesses and big foreign businesses engage with the government throughout, you know, when they come into the country and then throughout. So what I find is that it's important to have a line of communication with the government where they're aware of the benefits of your projects and also of your importance to the community as such and to the country. But also of the problems you are facing, so that they can help you, so that sort of, if you have an open line of communication, that always helps. You can also use your ambassador, so if you're a foreign investor, you should have frequent meetings with your ambassador to make sure the person knows you, knows what you are going through, so that they can assist you at an early stage, because they themselves have contacts within the relevant state. And then when a measure is pending that may affect your business, then it's always a good idea to be involved in also industry associations, because there is a strength in numbers. So I'm currently working on a case where the measures actually were agreed with the government, and between the industry association and the government. There is one disgruntled investor, hence I'm acting for the state, but the others seem to be happy with the outcome. And then, of course, then we had another issue last year where we thought it was futile, but both the client and us wrote all sorts of letters to politicians, including the president, had lots of meetings with everyone we could, with the members of parliament, etc., etc. And in the end, the president vetoed the law because she found that the reasons we were giving against it were cogent and that it would affect the investment climate in Slovakia. We too are still sort of finding our feet, just like India. So I would say always try and never give up before you really have to fight and have the expense of a treaty dispute.
Thank you. I actually have maybe an anecdotal question for Salim on this, which I'm just going to throw in there. But before I do that, I have an example of this cooling off period notice where, under most treaties you're required to serve it. And we served it on an Asian state for one of our clients. And they very politely responded very quickly as well and said, we reviewed and studied your notice and please come and have a meeting with us. So we flew there with so much optimism and we sat and we served a very, very big local feast, which, for me, that was a done deal already. But I finished the feast with my colleague and at the end they said, this is the only agenda item we had. We're not going to discuss anything with you, but we really hope you enjoyed our food and our culture, and we'll see you at the hearing. And then we, we flew home, and it was a very short minute of that meeting. So Salim, I wanted to ask you just on the comment about success in that period where the treaty or even a contractual mechanism requires you to engage in pre-dispute discussions. On balance, I know it's subjective, but would you say that that's effective, or is there a different way of doing it, or a different time in the chronology that one would do it?
Yeah, my experience is not great, I must say. These letters often end up, you can try and send them to various government departments, but having seen it on both sides, so having seen it from inside on states as well, we're often contacted after the cooling off period, as a lawyer, after the cooling off period has expired. And I don't think it's being taken as seriously as it should. So I'm not, and of course ICSID is pushing very hard now for mediation. We will see. There's that new impetus given by the Singapore Convention. I don't think the Singapore Convention does very much at all, but it creates a good buzz, so one can use it to push things. I remain convinced that the real way to address these disputes is to prevent them from arising. Because I do think that most bureaucrats, most civil servants, most people in government will normally act rationally, but they need to know what the parameters are. If you don't know that you're not going to be, sorry, I'm going to put it bluntly, you're not going to be in front of a court that will normally favor you, that has very limited judicial review, that will normally say, the state doesn't have the money to pay for this, I'm not going to order anything, but you might be in front of a neutral forum with quite loose tenders and you might end up being liable, you might think twice. So that's what needs to happen, I think.
Thank you. That's very interesting. And just that, and picking up something else that Lucia said, which I thought was very useful, as well as we've seen quite good use of this, is kind of trying to work out focal points. Like when you mentioned it's ambassadors or industry associations, just trying to find before it gets into the formal process where you can still invoke these bodies to sort of help you. I wanted to ask you, Zarina, like, are you, do you often, or have you been in a situation where you have to think like, how am I going to navigate this so as not to, get to the formal stage where I lose control? And is this something that you as an organization or that you've seen others do in terms of trying to work out who are their data points in a particular dispute?
Sheila, it's a work in progress. It depends on, if we move one step forward, are they going to take it at one step back? Are they coming back to us? It really depends on the kind of challenges we have in front. And it also depends on the level of complexity of that dispute itself. It's, when you say that one thing I will not agree with you is that if you think that I've come to the formal dispute resolution stage and you believe that I've lost control, no. I've always put it out there for everybody to know that a settlement can always be negotiated no matter at what stage. The number may move, and the number will move depending on how strong or weak I believe my case is. But I don't believe that I would have lost control at any given point in time. That is something that I need to keep. Otherwise, there's no point in the dispute resolution. I'm not going into a dispute resolution to lose it. I'm going in to win. So I'm not going to lose that.
I'm just pleased that there's only one thing that I said that you disagree with. But I was going to talk about this idea of kind of constantly having one eye on when is the right time to settle or mediate, and it doesn't, of course it can be at any point, right? And some of our best settlements have happened on the first day of the arbitration. Some of us walk away disappointed with our scripts and maybe read it to our children instead. But, you know, it's a good outcome for the proceedings. So yes, it can happen at any time.
Yeah, I'm thrilled if it's happening on the first day. I save cost, right?
Yeah, absolutely.
Hopefully.
Yeah. No, I'm with you on that too. Or wearing one hat. But actually, I wanted to ask maybe both of you from your perspective, I'll give you this mic in a minute. Do you think that at that stage, you should already have been involved in helping them come up? Is it actually less a lawyer job and more an expert job to say, look, this is the figure you ultimately want to work towards, and that's how you're going to maintain leverage?
Yeah, I know I have 3 lawyers here, so I can't say that's how it should be done. But yeah, I mean, as an expert, we do feel we are involved generally later than when we should be. And also, I think, a lot of our work is, educating, and I think Lucia said communicating. Because, a lot of time expert is initially thought of from a testifying point of view, but we feel there's a lot of work behind the scenes that needs to be done at various aspects. A lot of time we are working along with the lawyers, especially when we are working with the state, to kind of let them know, the focus on transparency, objectivity, and impartiality, because many times, we are in a situation where the state comes to us already with a number. This is what we believe, we would be open to settle, or this is what we should, eventually agree to, without maths backing it. It's their gut, and you have to spend a lot of time, telling them my role is not to justify that number. My role is to help you through the process, and that we are not your advocates. We are here to kind of help you very impartially get the decision or closer to what you want. So I think that's been a challenge. In terms of when an expert should be brought in, I think as soon as a dispute starts. I've heard the word complexity, and we are seeing increasingly disputes getting very complex. We are seeing the need for specialized experts and not, generic experts. We have seen instances where you need more than one expert, and if you leave that too late, I think you've lost the advantage that you could have had if you've prepared for it much earlier. And interestingly, we have seen in some instances, it's much smaller proportion, but people asking us, I'm talking about states here, before actually a proceeding commences, on what's your sense? Can you do a back of the envelope? Not a very detailed. And I think they do that to set expectations in their hierarchy, because, we are dealing with bureaucrats who ultimately need to go and represent to ministers, and, nobody likes bad news, worst case in a political setup. So I think that's where we have seen, some of the states come to us much earlier. I think one area, and not always best for us as an expert, is we do think many times sovereigns especially don't do as much research on who's the right expert. And sometimes we have been brought in much later after they failed with an expert. And I think that's where somewhere in the process they haven't given it enough seriousness. And but it's all a learning curve for them. But it does mean that they lose a lot of time, they lose a lot of money, and we have seen the claimants get super excited when they hear who the expert has been hired, because if they feel it's not the best by the state, that's where they feel they've won the game.
Really interesting. I was going to ask Zarina, and actually in a moment I might ask all of you by way of wrap up, whether you can give us like your top tip for what to do when you're in a commercial relationship or in a pre-dispute relationship with a state or state-owned entity. But Zarina, can I just ask, just on the back of what Tarun said, like just all the factors that you're thinking about, I know you mentioned the idea is you never do, you try never to lose control, right? And you have to be on top of the situation. Is there anything that you felt that has worked effectively from your perspective as a client that you've seen done that you thought led to an effective negotiated outcome?
I am going to completely agree with Tarun. If I hired the right expert at the right time and I got my numbers straight and I understand also where I'm going to be able to recover them from, my perspective on the end game is clearer. There's a straight line. There's a direct line to that. And if I am able to go in with that strategy and maybe change it a little bit, but with the help of strategic partners like yourself and like Tarun, where, we will see the evolving game, but we will know how we can get there. And we understand the mindset of the state as well. Because Tarun, I'm sure you understand the mindset of, like you said, maybe they've come in with the wrong expert, maybe they've come in with the wrong idea, or they've just come in with a number that they hope to achieve. But there is no backup to it, there's no legal documentation to that, there is no substance to that. Then how do we sort of get past and navigate that? Easier, more difficult, it depends. But we can get past that then, if it's just a number in the air. And I'll agree with him, there are times when we look at the expert and we do a little dance, because we do know that we can get past this easier. And then we do know that sometimes a new expert will be brought in and we will find it harder, but mistakes already been made, so we will capitalize on that. So, building on what you said, yeah, the right team at the right time, very important.
Okay, well, thank you very much for that. I'm going to maybe go through everyone one by one if I can and ask you, it doesn't have to be just the one thing, but what would you then say to an audience if they were dealing with the state on your advice? And as I say, the state can be your client, it can be a counterparty, it can be either way, but what advice would you give in that situation?
I think I'll take inspiration from Zarina. I think preparation is key. You have to, know what your bottom line is. You have to know how the numbers work. So yes, engage your expert early. You have to understand the government, their mantinels and how they operate. So I think a lot of thinking and preparation so that you can go in with a clear strategy and not just a number you are hoping to achieve.
The main thing, I think, is to act promptly and to be able to come to relevant experts, and I would include lawyers within that, as quickly as possible. So maybe if you're wearing the state, well, exactly, come to me. No, but you know what I mean. And on a state side, this would entail, which is also something that was trying to be done, but hasn't yet been successfully done here, identifying and sharing knowledge across, say, ministries as to who the right experts are in which field, to try and have an objective assessment of that, obviously to try and avoid nepotism, which is a problem everywhere, not just here. To have a list of good experts, good domestic counsel, good international counsel that you can go to for these cases, and then not save that initial, I would say £100,000 sounds like a lot of money, but spending that money to understand exactly what the parameters of your decision making are going to be is the best way to spend. And it may mean that you save millions after that. So that would be my advice.
Thank you, Zarina.
I would say, build on that, get your team right, and if you're going to lose, don't try.
Yeah, that's actually a really good point, right? Like building up your preparation and actually investing in that strategy, and then knowing then what to do and acting on it.
If the £100,000 says don't try.
Yeah,
It's the best 100,000 you spend.
Tarun.
So I think, from again closer to what we do, but broadly having worked with governments in different forms. What has worked is simplicity. I think we have seen at times consultants try and complicate things for the state.
You don't mean lawyers?
No, that's why I was very careful. I said consultants. So where we have been most successful is where you can set expectations in very logical, simple terms. It takes some time for them to accept. And my own personal experience, flowcharts work best with governments. If you can tell them, if you do this, this is what happens, and if you do this, because sometimes we go thinking we are the expert, lawyers, consultants, and so on. But I have come across a lot of bureaucrats who are extremely sharp. They know the matter so deeply that if you ask the right questions, you can actually get to the end point much faster. So yeah, simplicity.
Thank you. That's really helpful and almost sounds like a very cohesive strategy in this in this group of you, which at least from my own vision, it looks like it would really work. Before we wrap up, I just wanted to ask if there are any questions from the audience to this panel. Not to me, you're not allowed to ask me anything, but you can ask the panel questions. Yes. I think you have a microphone coming your way, if you can.
Thanks for this session. This is Vicky. A very good perspective, if you see from a 360-degree standpoint, how a lawyer would think the situation, how a consulting firm would do, and of course the council will do so. India is, what I've sensed till now since birth is, India is highly a sentimental market. And I see a lot of, I would say, when it comes to involvement of states, state parties, or even Union of India, there are a lot of guerrilla techniques being used generally for setting up the tone in terms of the bureaucratic power. I just want to understand, there will be some instances where maybe even you would have come across where it's actually shown as a might versus a corporate, and you may have to come up with such situations where you find a lot of pressure of dealing with counterparty being a state or a state party. So maybe it will be good to understand both from what would generally, Zarina, you would do from a council standpoint when you come up such situations, and maybe also from the consulting law firm category, if you can understand what would your advice be when you come up with such situations where there's a lot of might being shown in terms of guerrilla techniques, it could be a lockout, mass, it could be a strikes or something, which basically takes you to a different angle.
It is true that that we are a sentimental nation, but when you say, I personally have not come across a state where it's thrown something so nasty at me. I guess I'm going to say I'm lucky in that sense, but I haven't seen it personally. So I think from that sense, my experience in this is going to be limited, and I'm going to have to defer it to.
You just have to be prepared for any situation. We had clients detained, imprisoned, deported. That's better than detained. And you would then have to work with the local lawyers, with media, with politicians, with ambassadors. So you sort of have to have a fully fledged team to not just of legal advisors to deal with the situation. But normally, luckily, we always manage to get out of it quite well, and ultimately then just went to the state's detriment if they behave in that sort of manner.
Yeah, I think my experience with Zarina hasn't been as good as yours. We've had, these are highly political cases. Some states, behave pretty badly. I've had a witness actually disappear in the middle of his cross from one day to the next, and he was found in the Persian Gulf. So it can get pretty nasty, and absolutely, that's part of these cases, that you've got might against the corporate entity. And it all depends. I think it was very well described, by Zarina and Lucia. Depends on what your relationship is. Is this a place you're going to still be doing business in? Or if not, of course, tribunals have quite a number of tools that they can use in order to assist a claimant that finds himself in that sort of position with its directors being imprisoned, etc. You know, you've got interim measures that can deal with that. And, yeah.
Perhaps also then when we act for states, I mean, I don't know about the other advisors, but we always advise against that, right? So sometimes I will ask, should we stop these people at the airport, or you know, should we detain them? So you obviously advise
tell them not to
advise the government not to do that, and that everything has to be sort of really pristine, and if the person is in prison, they should be cooperative and allow representatives to come and at least take witness statements, etc. Because these things they just come back to haunt you. So when the state is well advised, they wouldn't do such things.
I have been in the government entity for last more than 3 decades. I heard Mr. Moollan the views on the pre-arbitrations, I heard the views of Mr. Moollan. I met him a decade earlier in my institutions for overseas arbitrations, and I agree that pre-arbitration discussions and the views of the chances of success, it matters, because we have been in one case. I was in the state HOD at Corporate Delhi. I heard the Madam Zarina and Mr. Tarun about the experts, cosmetic. Yes, there could be a better option if we go for the pre-arbitration settlement issues. Keep in mind your target, what is the strategy you have to adopt pre and during and post. And the most difficult part which we have faced recently before I demitting my office is the identifying the real expert KC or QC in the LCI London, and how we can really help us to really understand who will be fit for this sector, appropriate and expert the KC now.
Yeah, Zarina, before Salim comments, maybe Zarina, I don't know, I think it's a question around how you choose your counsel. Obviously, you have some choices on this panel, but I wonder whether you have any general comments, and then maybe Salim, you know, when you do get instructed, do they tell you why they come to you, for instance, is another way of putting it. But Zarina,
choosing your counsel, it is quite an art. A lot goes into it, your background, your experience, what we've heard from the market, what, let's say, other general counsels tell me. We do tend to do a good deal of research, because it's a good deal of money that I need to go to the management and say, we're going to have to shell out for you. So, and then of course it depends on the level of complexity of the case as well. So, how senior do we want to go? How is the state entity, how robust is their case? How good or bad is our case? There's a lot that goes into it. It is an art. There's no one single answer. It's not just market reputation. If it was market reputation, then none of the juniors would get a chance, right? But we do try and look at all sorts of experience. I mean, it's not like you are just a construction expert, so therefore I will come to you. I will have to look at the rest of your background as well to see what you understand, what you don't understand. How willing are you in working with me towards a settlement? How willing are you to working with, let's say, my own counsel that I've already got maybe in India? And of course, fees do matter, because when we do pay fees in foreign currency, the kind of exposure that we've got on our balance sheets to you as well is quite high. So all of those factors go into determining how I pick you.
It's quite a difficult question to answer. Maybe another way to look at it is perhaps what I think people in my position, myself, what changes, what do we bring when we take silk? When, what is it we're trying to do? What is it that might help a client with those complex cases? I think it's a given when you're looking for a silk, you obviously want someone who can handle the litigation. Of course, is a master of cross-examination, is able to do very careful, very well drafted written submissions and excellent oral submissions. That's a given. You have quite a number of people who can do that. What can you bring, I think, which is slightly different, and that's why I was saying this initial amount of money that you're spending in the beginning, is to use your knowledge and use all this that you would be able to bring to the case if it fights, to explain to the client in very simple terms, these are the options. Quite a complex matter, and this is what I would recommend and why I would recommend it, exactly as Tarun was saying, simplicity. And it's very interesting that the more years go by and the more simple your advice becomes. There are these anecdotes about silks 100 years ago they're about to go to the cinema and they get this very complex brief and they just write down yes and send back, and that's the way it ends up. And also someone who will, actually I would say someone who's busy, because someone who's busy will not mind whether the answer at the end of that initial X amount of money is no.
Add to that, I think also increasingly, especially for experts, I think how well prepared you come for your initial discussions, because I don't think your PPTs and your creds are good enough, especially on bigger matters. And like Zarina said, I think feedback matters. We have seen increasingly feedback taken from arbitrators and retired judges on their experience is also equally important.
Thank you, that's very helpful. Yes, one more question.
It's okay, I'll just ask. I have a very specific question. What has been your experience in realizing monies from the state parties or state entities post-award? Because as I know, usually after the awards are passed, the state will not pay you, at least in India. They will go in a 34, they will go in a 37, they will go in a Supreme Court. And in my experience, only after a warrant of attachment is put on probably on their head office, you will realize the money. So I have not at least seen where after you get an award, monies are realized from state. What has been your specific experience on this?
So, I think our experience has been slightly different. Of course, it's not that you win an award, you walk into North's Block or Delhi and there's a check waiting. That's not going to happen. So it's long, tedious process after that. But I think in my recollection, and maybe the others could have more context there, there have been only one or two instances where there is a threat of international attachment. I think there has been settlement in many matters by the government where they have ended up paying. I think from an original award to the final payment, whether it was the white matter or even recently Antariksh and others, I think anywhere between 20 to 50% was the final amount which was agreed and settled. So I agree with you that it's not that once you get the award it's done. It takes many years. But I think there has been enough examples of actual payment. But again, I'll let others answer.
I guess one thing I would also say to that is you do need a separate, or as part of your strategy, I think the end strategy matters, right? Like right up front to what Lucia and Salim and Zarina was saying about planning your, case strategy and approach, spending the money to work out what is going to be your approach. I think a very important part of that is what is the likelihood that they'll actually, it'll be easy to recover sums. And yes, there's often a perception of if there are court processes to be undergone, then sometimes it's not just that they want to be recalcitrant, it's that they have to, as a question of accountability. I was once opposite a actually state-owned entity, and they actually came to me very honestly and said, we have no choice. We have to, whatever you're going to win, then we will take it into 34 and then we'll see you in a year. And, we said, why are you doing that? You know that, first of all, the seat was not India, so why are you bringing a 34? And the answer to that was, you try telling, the people that I'm accountable to. So sometimes it's actually beyond, it's like a set system that's very difficult to break. But what I would say is exactly as Tarun said, I think they're different. It's important to know that of the counterparty if that is what you're faced with and factor that into your thinking. The other thing I guess on that is that sometimes you do get some people who specialize in that, like funders and people who will specialize and say, I'll take that risk or help you with that risk. And then, you can get a cut of that now and walk away. So maybe that's part of your commercial sort of battling with that as well.
And
political implications of a state being told to pay $1 billion and they pay it, it will have huge ramifications. So there is a process you need to show.
Yes, and outside of India, actually, states do pay, most states, I would say, but of course then there are some where it's more difficult. As Sheila said, you can sell your award at a discount if a funder will have it, and we have done that in relation to some awards. If you don't want to, then pursue the enforcement. In others, we did actually have payouts, and I think that's. And then the other point is that where they are a bit hesitant, it helps when they have sort of World Bank loans, because if you are at exit, you can then it can constitute a default under all their facilities. So that's proved quite helpful. That's obviously not helpful for India, but for other states that's proven very helpful, and we got then paid.
Thank you. I just want to say that I think we're between you and a short coffee break now, because there's another session starting shortly. So with that, I had some follow-up questions too, but I'm going to try and put it to a stop. But I would like to thank this panel. I very much agree with the views shared by the audience that it was just very interesting to hear all your diverse perspectives. And I think what was really amazing for me is it came together with a coherent strategy, in fact. So I hope you do take that away with you. Thank you very much for participating this morning, and thank you very, very much to this panel for coming into India or coming into Mumbai for this session. I'm very grateful.
Thank you.